decision, at paragraph 34 of that judgment, the court deals with what it says the approach under PAJA to delay is not the same as under common law. And then it says under the common law, a court may refuse to hear a review if there has been an unreasonable delay in instituting proceedings. What would constitute unreasonable delay would depend on the circumstances. And then it quotes from the opposition to Ebb and Tolling Alliance, Justice Brandt judgment, where he says, at common law, application of undue delay rule required a two-stage inquiry. First, whether there was an unreasonable delay, and secondly, if so, whether the delay should be, in all circumstances, be condoned. Let me perhaps dispose of the whether or not the EFF can be said to have not known about these issues that have been raised relating to Mr. Zuma's legal cost arrangement with the state. The affidavit, and here I refer to the affidavit of the EFF. Firstly, the founding affidavit is on it starts on page 7 of the EFF bundle. And you will see there that the deponent says that unless otherwise indicated, the facts in this affidavit fall within my personal knowledge. Park that and then go further from page 22 of that affidavit, where from paragraph 31, where the deponent deals extensively with Zuma's legal fees. And you will see there that it can never be suggested that the EFF only got to know about, firstly, that there was a state arrangement to fund Zuma's legal costs, and secondly, that that arrangement dates as far back as 2006. Because if one looks at what they say in paragraph 31, they say Mr. Zuma started as following in his affidavit, handed up to Peter Marisbeck, a High Court, Msimang J, on 31 July 2006, when he opposed the NPA's postponement application and instituted his counter application for a permanent stay. And then it says, as in the quotes from that 2006 affidavit, a specific consequence of the adjournment is the question of legal costs. And my lord, you can read that paragraph. The paragraph that is really important for purposes of determining whether or not the EFF can claim to have not known about the funding arrangements is in the latter paragraph of the quotation, page 23, where it says it is appropriate to raise in this regard the current status of efforts to obtain state assistance in respect of legal costs. And then it says the President's office ultimately decides on this. In the recent past, Dr. Passon, General Malan and others were so assisted because of their capacity as officers of the state at the time of the alleged commission of the offenses. A request for assistance was directed many months ago. The response was that the state attorney would act as the instructing attorney and fees for a specifically named senior counsel and junior would be provided. And then they go on to deal with those arrangements that involve the state. But if you go to paragraph 33 of that affidavit, you will see, if you go to paragraph 34 of that affidavit, now I have to be very quick to deal with this point. The second paragraph of paragraph 34, the second sentence, it says the only contemporaneous public record of the agreement on costs, the 2006 agreement on costs, is a newspaper 24 article dated 27 August 2006, a copy of which is attached, marked JSM 4, in which the following was reported. Jacob Zuma has signed an undertaking at the instance of the state that if he is found guilty, he will pay back the money he is asking for his defense in his corruption trial. Zuma has been refusing to sign an earlier undertaking prescribed by the office of the state attorney, which would have the state attorney become his instructing attorney, removing his trusted lawyer, Michael Halley. The point that we're making is that the EFF cannot claim to have not known this funding arrangement at this formation or when the EFF became representatives of the people in Parliament in 2004. So we would say they too, relying on the principle of legality, were enjoined to deal with this matter on the basis that they had delayed bringing the application to review these arrangements. Perhaps,
sorry, let me interject. But the question would also be, when did they become aware of this article?
of the what?
Of this article you are referring us to.
Is that they don't say, but it's clear, my lady, that the article is in the public domain as far back as 2006. So that question is important, because if the deponent had said, I only became aware of this article in 2018, that set out how far this arrangement, this funding arrangement has been in place, that would make a difference. But you will see that in the affidavit he doesn't make that point.
Okay.
And then it's important, the Honourable Court, for the Honourable Court to have to really drill down by looking at what the Supreme Court of Appeal says in Mosted, because there it sets out very clear principles that gives guidance to lower courts on how to deal with review applications of this nature, where there is clearly a delay in bringing out the application. But perhaps to close down on the issue of the EFF and the legality argument that they have submitted is the basis on which they seek to review this decision. May I refer you to the decision of Kumalo, which the EFF has relied on. It's on page 230 of the bundle of authorities that we handed up yesterday. And the paragraph that is important, amongst many other paragraphs that are important, is the paragraph in paragraph 44, the last sentence of that paragraph, which crisply sets out the legal principle relating to reviews under the legality principle. And it says, nevertheless, it is a long-standing rule that legality review must be initiated without undue delay.
Just a minute. Paragraph 44.
Paragraph 44, and is the last but one sentence. Is the last sentence of that paragraph.
Because I was looking where the paragraph starts. I can see where you're reading now.
Thank you, my lord. So it says, nevertheless, it is a long-standing rule that a legality review must be initiated without undue delay, and that courts have the power, as part of their inherent jurisdiction, to regulate their own proceedings, to refuse a review application in the face of an undue delay in initiating proceedings, to overlook the delay. This discretion is not open-ended and must be informed by the values of the Constitution. However, because there are no express legislated time periods in which the MEC was required to bring an application, there is no requirement that a formal application for condonation needs to be brought. Now, that's very important. That said, if one reads that judgment, you'll see that the court then goes ahead to criticize the MEC for failing to bring the review application in time, and accepts that the delay had been unreasonable. Here there is clearly an unreasonable delay. And the measure for unreasonable delay has been provided, at least the guidance to determining when one can say there's been unreasonable delay. We've been given guidance through section 7.1 of PAJA, which presumes that 180 days, a period after 180 days is per se an unreasonable period, which requires a section 9 substantive application. My ladies, let me then refer you to the case, the case of Oregon, the Oregon judgment, which is in page 83. I mean, the paragraph I'm referring to is in page 83, but it's also the Supreme Court of Appeal judgment. It's on page 83, particularly paragraph 16. This dealt with the argument about when the city would have known the decision which they sought to now review. And the court says, perhaps I should just read it, the decision challenged by the city and the reasons thereof were its own and were always within its knowledge. Section 7.1 unambiguously refers to the date on which the reasons for the administrative action became known or ought reasonably to have become known to the party asking its judicial review. And then it says the plain wording of these provisions simply does not support the meaning ascribed to them by a court of law, i.e. that the application must be launched within 180 days after the party seeking review became aware that the administrative action in issue was tainted by irregularity. That interpretation would automatically entitle every aggrieved applicant to an unqualified right to institute judicial review only upon gaining knowledge that a decision or its underlying reasons of which he or she had been aware all along was tainted by irregularity, whenever that might be. The result is untenable as it disregards the potential prejudice to the respondents and the public interest in the finality of administrative action decisions and the exercise of judicial functions. Contrary to the court's course finding in this regard, the city far exceeded the timeframes stipulated in Section 7.1 and did not launch its review proceedings within a reasonable time. So that simply disposes of this notion that somehow, both in the DA and the EFF application, somehow one must look at the date when they became aware. Firstly, in the DA application of supposes that they knew that the state was involved. Because if this was money paid from the personal resources of Mr. Zuma, the MP of the DA would have no business asking in 2008 the state or the relevant executive member of government to explain the amount of money that had been paid in Mr. Zuma's legal costs. And there was a little debate yesterday about which decision whether there are a series of decisions and which one are we looking at. Whichever one you look at, they all fall outside the 180 day period prescribed in Section 7, and we submit that. Long time ago, and of course.
So we don't know how you'll share the time because the report is really a Reserve Bank report, if I understand it, commissioned via Ms. Advocate Mutau. So welcome everybody. We have also the Hawks here, the NPA here. Everybody's here according to the committee secretaries. Thank you very much.
Good morning, Chair. I'm going to do precisely what you asked, to give a brief update or a brief summary of the report in some ways, but I'll also cover one or two other issues in relation to VBS.
But you also give the advocate some space to speak as well.
Sure.
Yes.
Just a brief background. VBS Mutual Bank was placed into curatorship on the 10th of March. The initial work of the curator found fake deposits, large related party loans, significant bad loans, in other words, loans that were not being repaid, weak systems, and possible fraud. The financial statements and the data returns to the regulator were not an accurate reflection of reality. I think it was on the 13th of April, the Reserve Bank appointed Advocate Terry Mutau, Senior Counsel, with the support of Werksmans to conduct a forensic investigation into VBS. Periodic reports were received to the Prudential Authority during this process. Based on these periodic reports, three things happened. One, the curator successfully applied to the court for the provisional liquidation of Vele investments and the provisional sequestration of 5 individuals. Two, the CEO of the Prudential Authority laid a complaint with the DPCI. And three, the SARB met the National Prosecuting Authority to brief them on the matter, in particular the alleged fraud in relation to a very specific issue, the falsification of accounts and data returns to the South African Reserve Bank. Chair, on the 5th of October 2018, Advocate Mutau presented his final report. Attached to the report is a detailed forensic report on financial flows with all the evidence obtained, the transcripts of the interviews conducted. In summary, the report says that there was massive fraud committed with about 1.9 billion rand looted from the bank. 53 people or companies received money from the bank, with 27 named in the summary report. That the lead audit partner from KPMG, Mr. Sipho Malaba, was complicit in the fraud and cover-up. That bribes or commissions, depending on your language, was paid to politicians, municipal managers, and other lobbyists to solicit municipal and other public entity deposits. And that VBS and Vele were intertwined in a conspiracy to defraud depositors. Chair, in summary, the report has been made public. The detailed annexures, however, have not been made public at this stage, as they could potentially jeopardize the investigation and asset recovery. So it is certainly my intention to make those annexures public at some point, but we'll have to take the advice of the Hawks and the NPA on this matter, because we don't want to jeopardize the investigation or the asset recovery. The main modus operandi of the fraud is as follows. The bank creates fake deposits in the name of a related party. The bank solicits deposits from municipal or public entities. These municipal deposits are then withdrawn against the fake deposits or are used to grant loans to related parties. Related party loans are extinguished with fake payments and accounting entries. The CFO falsified the accounts and the monthly data returns to the SARB. These financial statements and monthly returns were signed off by the external auditor. In this regard, the bank was effectively a Ponzi scheme to the benefit of certain related parties. Others were paid to keep quiet or to look the other way. The key recommendations of the Advocate Mutau's report is that the report and the detailed annexures should be handed to the DPCI, SARS, the Asset Forfeiture Unit, and the NPA, that criminal charges be filed against key protagonists, that the bank should be wound up, that the SARB, National Treasury, and Curator should consider suing KPMG. Chair, the first two recommendations have been accepted and implemented. The fourth is still under consideration, and I'll deal with the third in a minute. Chair, just a quick report. The 100,000 Rand guarantee fully covered the deposits of approximately 97% of the retail depositors. That's excluding related party accounts. The repayment process is proceeding well. Customers have 3 years to claim their funds. To date, about half of the depositors have visited a Nedbank branch to activate their accounts. Some have withdrawn their deposits in cash, some have transferred amounts to other banks, and some people have kept a portion of their deposits with Nedbank. Let me deal with that third recommendation now, and in particular the issue around liquidation. Chair, in early October 2018, I think it was the 3rd, if my memory serves me correctly, the curator wrote to the Prudential Authority informing the PA that he had compiled the restatement of the 2017 accounts on a best effort basis. Chair, at our previous meeting, we reported that we have asked the curator to
of the law. Firstly, because the funding decisions were always predicated on legal opinions that were obtained from state lawyers, who assured the president that this decision would be legally competent. Whether they're right or wrong, that's another question. But it demonstrates that they reasonably engaged with the issues, applied themselves to the legal principles that are engaged in the decision, and came to certain conclusions that were defensible. So there can never be a suggestion that these decisions were recklessly taken, and it was just as the EFF would have us believe, that this was just a reckless and unguided exercise of power that resulted in Mr. Zuma litigating at will.
Mr. Masuku, on that point, if you look at the chronology that was presented by the EFF, if my memory serves me well, Mr. Nilagai Toby referred us to certain decisions that were taken before the legal opinion was sought. Do you remember that?
Yes, I remember the submission that he made was that the money was paid and then legal opinions obtained after that had been done. There's just one submission I would make in that regard. What it demonstrates is not recklessness. It demonstrates a reflection. The fact that you take a decision and then you question the decision, you say, did we do the right thing? And then you engage properly by looking at whether or not you, in fact, your decision is defensible. You could criticize the attorney for it, but it could never rise to the level at which you could say it was recklessness of the nature that the court says is egregious. Because if the state attorney, on reflection of his decision, came to the conclusion that they were wrong, and despite that conclusion, nonetheless continued to uphold their decision, then we could say, well, you yourselves came to the conclusion that this decision was wrong, but you nonetheless continued to embrace the decision and implement it as if it was correct. Mercifully, in this case, the state attorney came to the conclusion that their decisions were correct and legally defensible, and that the decisions could be implemented. So that doesn't help the EFF's argument. But let me deal with the EFF's argument on the PFMA. I'm going to come back to the arguments on the state attorney, the interpretation of the state attorney. But before perhaps I go to the PFMA argument, which I'll dispose in a moment, we have made submissions on the interpretation we promote of Section 3 of the state attorney. It's on the heads of arguments. I do not propose to trouble the court with any intense legal submissions, except one or two components relating in response to what my learned friend especially for the EFF said yesterday about the issue of cause and scope and the reference to the charges that President Zuma is facing. The PFMA argument has no merit at all. Firstly, it's not clear from the arguments whether or not the procurement of Mr. Hali should be done by the state attorney or should be done by Mr. Zuma. But obviously the PFMA would not apply if it's done by Mr. Zuma, the procurement of Mr. Hali's services.
Doesn't Mr. Zuma say it was his attorney?
I beg your pardon?
Doesn't Mr. Zuma say in his affidavit that it was indeed his attorney?
Yes, he does say that. But so the argument I'm making is that, so when we're exploring whether or not the PFMA argument stands, we must look at what exactly he proposes should have been the procurement method adopted and who should have been procuring Mr. Hali for these services. But let's take the state attorney. The State Attorney Act, the State Attorney the State Attorney are government attorneys. They act for government. So where an issue involves government, State Attorney steps in immediately. They don't have to go through any procurement problems. But secondly, if one looks at Section 8(1) of the State Attorney, and perhaps we should actually look at that. It's in the bundle, and it's on page 7. And the Section 8(1) says the State Attorney or the person in charge of a branch of the State Attorney's office shall be entitled in the exercise of his functions aforesaid to instruct and employ as correspondent any attorney or other qualified person to act in any legal proceedings or matters in any place in the same way as, subject to the same rules, terms and conditions as govern attorneys in private practice, and shall be entitled to receive and recover from such correspondent the same allowance as he would be entitled to do if he were an attorney in private practice. The reason we raise that is that, well, what happens when an urgent matter requires the attention of the State Attorney and the State Attorney has no capacity to deal with it? We think
because the report is under challenge, many of the issues will of course have to be dealt with in answering that application, and I would not be at liberty thus to engage with some of the issues that may or may not arise here, about why certain things happened in a particular manner, why.
So it's not just limited to correspondent. But even if it were to be a correspondent,
but when you look back at Section 3(1), it talks about the fact that the general interpretation, the State Attorney must do all the work that can be done by an attorney.
Yes.
We agree on that. And on Section 8(1), it talks about where the State Attorney does not have an office and it needs to appoint a correspondent. That's how I understand it.
And if that correspondent is a private attorney, my lord, the argument, as I understood it, is that the State Attorney, if it's a correspondent attorney, the State Attorney would have to comply with certain requirements for appointing a correspondent to perform the work of government, because by law a private attorney would not be entitled unless appointed by the State Attorney to perform the work of government.
But the correspondent is just a post box.
No.
They'll just receive the documents, send them back to the State Attorney.
No, but my lord, if you
send the documents to them for service on the other attorneys who are within the radius required by the rules.
My lord, I mean, of course, your lordship will I'm glad that it's a problem that you have to deal with. But I make the submission that if you read Section 8 in totality, it's capable of interpretation that goes beyond simply saying a State Attorney can appoint a correspondent. It's capable of that. If I'm wrong on that interpretation, then I'm wrong on it. But the submission I make in respect of these requirements that my learned friend imposes on the State Attorney, that when they engage a private attorney, they ought to comply with procurement regulations. Let me show how upset that submission is. Firstly, as I pointed out, what happens when invariably there are a number of problems. The first one being that assume the State Attorney does put out a tender and 5 law firms tender for that work.
I think I understand the submission you are making. By way of example, if they are going to brief counsel, your submission is that they don't there's no need for them that they should go by way of tender. They can just go to any council without tender being published.
Yes.
That's your argument in your submission.
Thank you, my lord. You've put it crisply. And then, of course, there would invariably be delays where tender system is followed, and that those delays may, in fact, result in the court being unable to resolve cases that are urgent expeditiously. And, of course, there are potential disputes that may arise from these procurement decisions and processes. Those disputes would freeze the functioning of the courts, because now you're going to be dealing with disputes between attorneys over who should have gotten this job and who shouldn't have gotten this job and who scored what and not what. And then, of course, that would create problems. Let me, my lord, perhaps my land junior has just given me a good point, which I should point out. The argument about the correspondent. Let's also just remember that the correspondent attorney, the mandate for the correspondent attorney is determined by the instructing attorney. There are just no limits on what the state attorney may say to a correspondent about the nature of work that they ought to perform on its behalf when they deal with that. They're not just a post box. That mandate goes beyond just being a post box.
The state attorney
that's
or any like professional person appointed.
And be that as it may, the state attorney has got an office in KZN, so there was no need that they should appoint a correspondent attorney.
yes. The reasons why Mr. Hali was appointed are set out in the various submissions made, I think, by the president and also by the state attorney itself and by Mr. Zuma himself, and it relates to the conflict that would arise with the state attorney representing the NDPP on one hand and also representing Mr. Zuma at the time.
That concludes that point. That
No.
means that the attorneys appointed were attorneys appointed by Mr. Zuma, as he says, and they were not attorneys that had to account to the state.
Meaning of account.
Scripts of the
in agreement with that proposition, my lord. And it goes further for me in terms of the arguments relating to the PFMA. I pointed out in terms of the PFMA that there are intractable problems, submitting that the appointment of Mr. Hali should have been, in fact, subjected to a procurement process, in terms of which there was a whole range of controls that that my learned friend for the EFF set out yesterday, which would have justified the appointment of Mr. Hali. That's the point. That's really the point that I was making. I was not making the point that Mr. Hali per se was appointed in terms of Section 8(1). My lord, let me deal with the argument on the submission on the equality argument. It's not clear what exactly the argument is on the equality argument, on the equality matter. It appears that my learned friend says, on one hand, Mr. Zuma is a president, which is true. He's not an ordinary person. In fact, the EFF judgment, the EFF versus the public protector judgment in the EFF matter of Chief Justice Mkhweng explains exactly what the office of the president signifies. So my learned friend is correct. Mr. Zuma was the president. He's not an ordinary litigant, and that's the point he makes. But then when he talks about the Equality Act, he then says, well, he's not treated like us, the ordinary folks. But I mean, if the equality argument has to pass, it has to be president to president. If the argument was there are two presidents, both facing criminal charges, one was treated better than the other, then that argument would potentially thrive. But this argument doesn't thrive at all, because my learned friend is not suggesting in his argument that Mr. Zuma has gotten preferential treatment that other state officials have not gotten. We give the example of Mr. Silebe, we give the example of Mr. Passon. Both were given state assistance on the basis that they were state officials. And there are many others, I'm sure, that with better record would demonstrate that where the state has decided that a particular official should be granted state legal assistance and the funding that goes with it, there can never be an argument on unequal treatment in that respect. And of course, the submission that we've dealt with, the submission that, well, Mr. Zuma, if he doesn't have money, he should go to the legal aid board. Well, I mean, if the concern is about public funds, legal aid board also has public funds that are being used everywhere. The simple point is that the Equality Act doesn't at all make a case for any review of the state attorney's decision. There are many reasons, my lord, why the state attorney's position is very important, and why this facility of providing officials of government with state funding is very important. And I'm dealing now with an aspect of the argument that relates to the interpretation of Section 3 of the State Attorney Act. So one must look at what the purpose of the state attorney is: to represent government in its litigation, provide legal assistance to government. Now, any news that a judge has been charged with an offense invariably involves state interest or government interest. Why? Because of judicial independence. Because the government would say, and of course they've got to do everything they can in terms of Section 165, I think it's 4 of the Constitution, to protect the integrity of the office, the dignity of the office of the judge. So if a judge is accused of a terrible offense, which does not fall within the functions that judges are normally appointed to perform, the government interest is judicial independence. So when they provide state legal assistance to a judge, on the control that if he should be found guilty, he'll pay the money back. Their interest is judicial independence, because they're protecting the office. They're saying to themselves, look, we cannot expect the judge to pay for his or her legal costs, because if he does, we'll bankrupt him or her. And if he cannot defend himself, then how can the judge ever perform judicial functions? If he's taking from his or her own pocket, it would become quite untenable for a judge to continue serving as a judge. So the threat to judicial independence that comes from accusations that are untested, just accusation, you're just accused. There's no evidence yet. You're just an accused. The point that we make is that it is very important that we never diminish the value of the government interest or the scope of government interest in protecting the offices, the officials that make the government run. So the point is that when they...
Is your point no matter what the judge is being charged with?
It's no matter what the judge is charged with.
Even if he's charged with housebreaking and theft?
Even if he's charged with rape. We say it's just an allegation.
And drunken driving?
And drunken driving. We say the state interest there is judicial independence. And remember, the control here is that if you should be found guilty, you pay the money back. But our interest as government is, well, you know, our judges are a symbol of our judicial system. They are guardians of our constitution. If they should be rendered unable to perform their judicial functions simply on allegations, or rendered unable to perform their functions because they are now required to pay from their own pockets to defend themselves from whatever allegations they face, that would not be consistent with what government should generally be doing to protect its own independence. I'm not suggesting at all an unguided sort of a view on it. There are certain instances that may well, I can't think of any now, but there may well be circumstances where the nature of the allegations are such that the government can say, look, I mean, we certainly do not see how government can protect this aspect.
But Mr. Masuku, I think maybe we should qualify, or you should qualify what you're saying. Your argument now relates to the state attorney assisting maybe a judge or a president. But in Kasu, the case that we are busy with, the state attorney did not assist Mr. Zuma with legal assistance. It was just a question of funds being paid to Mr. Hali, is it not?
No, so the real... Mr. Hali wouldn't act if there was no funding. So we say the fact that the state is providing that assistance, the funding assistance, is state assistance that qualifies to be regarded as the kind of assistance we're talking about. It's not private assistance. So we're saying the real issue is that but for the undertaking that the state, or but for the state legal assistance in the form of funding.
I understand the issue to be that the state attorney did not, that office did not assist Mr. Zuma with legal assistance. They were just the source of the fees for Mr. Hali.
Yes, no, we understand it similarly, my lord. I am not suggesting anything different, but I'm submitting that in that relationship that you've just sketched, we must read that the power behind the legal assistance that Mr. Zuma is getting is the funding that he gets from the state. That Mr. Hali is able to provide legal assistance to Mr. Zuma because he's covered financially, and that cover comes from the state.
Was just used as a bank to give a loan for the fees that they could recover later.
Yes, and we can call it whatever we call it, but I think my lord, in fairness, it's not an unusual facility in government.
It has happened before with
it is in fact it happened for yonkies of years.
That does not make it right.
You will have to make that determination, my lord. I hope you have not prejudged the outcome of that question.
No, I'm listening to the argument.
Yes,
that's why I'm raising this things to understand your submission properly.
So the point really that I'm making is that the nature of government interest ought not to be simply determined by the nature of the allegations that are made. It must also be determined by the the interest of government. For example, when President Zuma was deputy president, that's a constitutional office of the deputy president. I mean, it's part of the, it's referred to in the constitution. So,
But your point is Section 3 of the State Attorneys Act authorizes the funding of legal costs incurred in the defense of an official such as Mr. Zuma.
that's very basic. But I would say to the court, perhaps
No, but that was the decisions taken were based on Section 3.1 or Section 3.3. The decisions to fund.
And we can't get out of it. We can't get out of that. That's what the state attorney says.
Yes.
And we can't get out of it.
Now,
and we
either
support
that
that.
decision was correct or not.
Yes.
Either that decision was authorized by Section 3 or it was not.
Yes. Yes. And you have the arguments on that, my lord, and we submit that when you look at the arguments around cause and scope of employment, cause and scope of work, you do not simply look at the fact that this assistance had to be given on the basis of a predetermination it had to be given on the basis of a presumption of innocence. It can't be given on the basis that the estate attorney must assess whether or not actually does this fall within the cause and scope of the employment. But it must be based on the fact that we understand that the judge has been accused of this thing. We make no judgment on that. We're going to assist him or her on the basis that if he's found guilty, we will then recover our money. But that also helps with the cases that my learned friend referred to yesterday. The Black Sash case, where personal costs were granted against an executive member. What happened there is that the court engaged with the issues. There was evidence. The court could come to the conclusion that this was not in the cause and scope of employment because it had engaged with the evidence. And it had determined that in terms of the evidence before it, that was not the position. And then it could make a judgment. Even the cases that involve the police or whoever else, the approach would be allow the courts to make that determination of whether or not it's in the cause and scope. Don't leave it to the state attorney. The state attorney can't simply decide that this is a matter that falls within the cause and scope of the employment. Therefore, we're not going to fund the decision. Of course, I mean, they may well get it wrong, and I understand that there is a case where they refuse the police officer the funding of the state, but so may well have been, we can engage with the facts in that particular case and see whether or not it would be correct for the courts to impose a duty on the state attorney when they're considering these matters in terms of how they understand the act itself, to make that call of whether or not they can refuse state assistance simply on the basis that they believe that this was not in the cause and scope of employment.
But Mr. Masuka, do you agree that the legal functions performed for Mr. Zuma in all those cases were not performed by the state attorney?
I think we've made that position.
Concession.
Yeah, it's not a concession. It's a common cause.
May just assist me on this. On what basis did the state attorney fund the legal fees? Is it Section 3?
In their arguments,
yes,
that in their affidavit, my lord,
yes,
so they rely on Section 3.1 and 3.3.
And what is your submission?
Our submission is that it is competent to rely on Section 3.1 and Section 3.3.
Yeah, but also I still do not understand that if Section 3 says the state attorney will provide legal services, how does it now change to become a funding of the legal services?
Yes, sorry, my lady. There was my learned friend for the DA did attempt to actually answer how the system works. So the decision maker is the president. And you'll find that in JS6 that I referred to earlier on page 51 of volume 1 of the DA case, and it's also in the FF case, where the president goes into detail, the Department of Justice and Constitutional Development, I think it's Correctional Services, explains exactly how the decisions are taken. So the funder is the department, is the presidency. The comfort to take that decision to fund a particular litigation involving an official in the presidency would come from advice that the state attorney gives to the department. So the state attorney would say, look, we've looked at the case. We think there is a government interest, and we would support that the department actually funds this particular litigation.
Yeah, but in this instance, I think you have already considered that what happened is that only funding assistance was given to Mr. Zuma.
Yes.
But
so
the State Attorneys Act Section 3 says he must be provided with legal services, not funding.
no, I don't understand, because legal assistance.
Legal assistance, yes, in the in the sense that the state attorney must act for the litigant, not be given money to find his own attorneys to act for him.
No. So we as I say, my lady, one must start off by looking at the purpose of establishing an attorney that acts for government, and then one must say, how does one? So section 3(1) says the functions of the office of the state attorney and its branch shall be performance in any court of such work on behalf of government of the republic as is by law, practice, or custom performed by attorneys, notaries, and conveyancers. So we now know that the state attorney are government attorneys. They perform functions just like any other attorney in private practice, either as notaries or that.
Which do not include funding.
No. So
Those are legal functions.
So the papers do say, my lord, that the decision maker on the funding aspect was the presidency. It was not the state attorney. The state attorney recommended, gave an opinion, supported, and gave the comfort to the presidency that they could, in fact.
The decision to fund was taken on the basis of 3(1) or 3(3). This is why I put it to you. That is where the authority, whoever was the decision maker, the authority for that decision maker is alleged to have come from 3(1) or 3(3). So, and now we know that 3(1) authorizes the performance of legal work, usually performed by attorneys. Which is not funding.
It does not say fund.
That's a function performed by financial institutions.
I can see the difficulty you're raising, but the submission that I'm making is that the role of the state attorney as a government attorney is to advise departments on litigation that may implicate those departments or officials in that department. So when the state attorney is asked to provide legal assistance by a department, it provides that assistance. And in this case, what they did was they assured the presidency that a decision to fund a decision to fund the legal costs of Mr. Zuma was competent. So what is the
3(1)?
Yes. So what is the
debating with you? Was it competent in terms of 3(1)? That's the question for us.
my lord, it was competent. What is the state attorney doing? They are asked whether or not a matter that the presidency, that implicates the presidency, is involved in. They are asked, can we fund this particular case? The state attorney, as attorneys of government, provides a legal opinion on it to the presidency. They say, yes, you can. You can fund this particular, you can, in fact, decide to fund this particular litigation. They are competent to do it under Section 1 or Section 3. And that's what they did. So what the advice that they gave to the department was that it is competent for that department to provide legal funding for litigation involving a particular official. The presidency then takes the legal opinion, it reads it, and it says, okay, conveys back to the state attorney, we can do it. We will do it. We'll provide funding cover for this particular case. So as government attorneys, the state attorney then says, okay, we'll act in the matter. In this case, it's different because the advice they get is also that they're a bit complex in this matter because the official involved sits in the presidency, yes, but and so we cannot really act in the matter because there would be conflicts because of the fact that we act for opponents of this particular individual. So how do we resolve that conflict? Get a private attorney to act for Mr. Zuma in order to cover, and that the state would cover the services of the private attorney, which would otherwise have been performed by the state attorney had the state attorney been in a position to do so. So my submission, my lord, is that we've got to interpret this act in a way that is enabling, in a way that will enable the state attorney to be effective in how they advise government, and not in a way that would restrict them. They are attorneys for all intents and purposes, like every other attorney, and they perform the work of attorneys. So where they are not able to perform because of a conflict, what do they do? It's got to be practical.
Assist me on this point, Mr. Masuku. A department is authorized to seek legal opinion and to pay their advisors separately without involving the state attorney. Is that not so?
Yes.
And in this instance, Section 3.1 says that the state attorney should do the functions of an attorney, which means, in my view, if they are expected to do what is not within the cause and scope of what an attorney can do, they should refuse to do that. For instance, a state attorney cannot be expected to come and fix the air conditions of this building.
Much as I would like them to do that, my lord.
Yeah. But they can't. So, in this instance, because the presidency, or let me rephrase it, the presidency could have told Mr. Zuma directly that instruct your attorney and then we'll fund it without involving the state attorney.
No. They could have done that through, because remember, the president does have his own, they have their own legal advisors. Their own legal advisors could have given that advice, but they didn't go that route. They went the route of the state attorney. That was not incompetent, because the state attorney were in giving advice to the presidents, were exercising what attorneys generally do, give advice to their clients.
Yes, they did give advice, but why were they the people now who paid for the accounts that were sent?
No, but because the funding, the budget for that payment is ring-fenced in the presidency, so all they do is they pay from whatever budget they have, and then they claim back from the presidency the amount of money that would have been paid.
Okay. You may proceed.
Okay, so I've made the point that the money comes from the presidency, and not the state attorney, which controls that budget. Lord, why do we have this? What do the applicants tell us are the reasons why they really brought this application? If you look at both the EFF and the DA, they say we bring this application because we want accountability. State funds have been abused. Mr. Zuma is abusing the courts without a shred of evidence. I say no more than just saying it's got no basis. The allegation is that the fees were exorbitant has no basis. We are not told why they believe they are exorbitant. We are simply told that, we are not even told what comparator they are using for a 15-year time frame or litigation that has gone either 10 years, let's put 10 years, why these fees would be exorbitant. Bear in mind that we actually don't know the actual figure we're dealing with. We can work with what the President Ramaphosa has said, 15 million.
No, I think they said 16.5 million.
Yeah, 16.5 million. So we can work with those figures.
No, that's the only invoices they've so far received from the state.
Yes. So,
but the EFF mentions a figure of
32 million, yeah.
So it's anywhere between 16.5
right.
to
We don't know why.
Million, it seems.
We don't know why they believe that figure is exorbitant. I mean, it's exorbitant because it's 16 million here. But what is the evidence that the court can comfortably say, having looked at this evidence, we believe this was exorbitant? There's none. There's absolutely none. And perhaps yesterday I didn't answer the question your Lordship put to me relating to whether or not if Mr. Zuma had been funding his own litigation from 2008, he would have litigated as he did. Perhaps he would have.
Well, we don't know, but...
Yes, perhaps he would have. We all know that the litigation involving Mr. Zuma has never been frivolous litigation. It has raised issues that has engaged the courts of this country very intensely. Very intensely. It's raised very profound constitutional questions that have been answered. So the country is richer in terms of the law because of the litigation that has involved Mr. Zuma. And remember, he was not always the applicant. He was dragged in these courts, sometimes, particularly by the DA and the EFF.
But that's not the argument raised by the applicants. They're not saying the proceedings were frivolous or vexatious. They're just challenging the manner in which this funding was conducted.
It's not just the funding, my lord. The point I'm making is that the basis for bringing this application is, this President Ramaphosa has just told us that Mr. Zuma is going to be, is going to be supported financially by the state to defend himself. No, it's too much. Accountability demands that that particular dispensation stops. Transparency demands that this must stop. These are constitutional principles that ought to be applied in order to stop this attempt to evade justice. That's what the DA, those are the allegations they make against Mr. Zuma, that he has litigated to avoid his day in court. But of course, it's the DA. I mean, what can they say about Mr. Zuma other than to say those kind of statements? They're political statements that are intended to hurt him politically, not legally. They are not legal submissions at all. Because firstly, they don't tell us exactly in what respects this litigation can be considered to have been reckless. They don't tell us that. They don't tell us that even when a party loses a matter, it doesn't necessarily follow that they were reckless. I mean, if the DA loses this matter, it doesn't follow that they were reckless. Which I hope they do, by the way.
I'm sure you do.
Yes. So I'm saying, let us not suggest that because a party lost a matter once, twice, 3 times, however times, that it necessarily is a reflection of recklessness. The matters that involve President Zuma or former President Zuma are matters that have been recognized as having a public interest. That comes from the mouths of the DA and the EFF itself.
I think it's made in submission.
Yes. And the Supreme Court of Appeal, in one of its judgments, does acknowledge that these matters have engaged very profound public interest matters. I mean, of course, the DA and the EFF do say that they bring this matter in the public interest. Firstly, they bring it in their own interest, in their own political interest or legal interest. But they also say that they bring it in the public interest. So it cannot be that they are in the public interest when they are involved, but they are not in the public interest when Mr. Zuma is involved. So I would say that to the extent that you intend to go to the review route and deal with this aspect, which you say you shouldn't, this matter is clearly, or the matters in which Mr. Zuma has litigated on, clearly raised issues of public interest for which the state was entitled to look at and say, in the interest of the public, these matters do require this kind of funding dispensation. So there were submissions made by my learned friend that when the president became when Mr. Zuma became president, there may well have been a manipulation of the state attorney. There's no basis for it, and your lordship did immediately say, but there's no evidence to that. And I hope it doesn't go further than just what the learned deputy judge president said. There is simply no evidence to suggest that there was any corruption involved between the state attorney, Mr. Zuma, Mr. Hali, and the presidency. No evidence whatsoever. And to the extent where the cases have referred to potential for a court to exercise a discretion to extend the time frames for late filing, they've said, well, sometimes matters involve corruption. And where they involve corruption, yes, the court might say, well, these cases actually involve corruption. There are allegations of corruption that ought to be answered, and this has not been, there are not a single allegation of corruption that I could find in the papers of both the DA and the EFF. All they complain about is that, well, Mr. Zuma's litigation must be stopped because he must go and face his trial in Pietermaritzburg. But we all know that our constitution, which is the supreme law, entitles every citizen from the top to the bottom up, all of them without reference to status, whatever, to access courts. And it's very important that that point is emphasized, because we're safe when we're in courts. We're safe because our courts are institutions of adjudicating disputes impartially, without fear or favor. They don't look at the person that is involved. They don't look at the party that is involved. They look at the issues that are involved. So they are safe platforms to adjudicate disputes. And so when Mr. Zuma is faced with problems, legal problems, and he decides to use the courts, we shouldn't assist political parties to come and scandalize that as an abuse of the right to access courts without any basis at all, with no evidence at all. So we do make this in our heads of arguments. That
are you saying if the state attorney is not going to fund anymore, Mr. Zuma's right to access the court would have been interfered with?
No.
Okay. All right, no. You'll address us further when you come back at 1:30.
Oh, shucks, I was hoping to finish.
Unless if you're not going to keep us for more than 5 minutes, we can listen to you.
No, I think my attorney says I must take a break. He pays my bill, so I have to listen to him a lot.
Court agents?
I don't care now.
Section 1, section
Because that's what they will come down to and say, actually, I mean, you know that because it's a moving target who actually make the decisions. Because sometimes the president advises the state, sometimes it instructs.
He's coming. He's late.
Well, I know the problem is this guy's going down.
Because everyone says to me, and they have never given me I actually ran the experiment again, and then I started thinking, why is it that I never implemented this? I actually ran the experiment and I kept changing You've literally made us the first time I hear one. It's perfect.
And he's a good dad. I mean, look at this. Very good dad.
Yes, they're like good. You can never say he's more than that. He's still with murder.
And the kids get pieces. And they get pulled up. That's child abuse.
Yeah, I think it's because
Yeah, so sometimes
Are we getting copies made?
Yeah.
Have you moved? Are you sitting in the
Also, can you just explain yourself? What's that intent? What's that intent?
Our next line will be
As soon as I say that, if we analyze objectives. Yeah, I mean, the way to do that is increasingly towards the city government. Sometimes it's 30, which is honest. So apparently I put him in bed next to me. Where his dad sleeps. So he was working, whatever, roll over. And occasionally we give him hugs and kisses and go back. And then I said, okay, I must go to bed. So he got out of bed, he was running around the whole What? Mommy, what? I was like, I'm going every time I really come to there, Auntie says,
we genuinely tried to save VBS. Right? We genuinely tried. In fact, in African Bank, we put money into African Bank, the public will not lose a cent of that money. Right? Taxpayers are not in the hawk for 1 cent in African Bank. But I can assure you taxpayers are going to lose money in VBS because the money that we put in to cover the deposits will not be recovered. We may get 20, 30, 40 cents in the rand, but taxpayers will lose money. There has to be a specific legal process between the Minister of Finance and ourselves when we put taxpayers' money at risk. Right? I want to repeat the point that in African Bank's case, the curator found significant wrongdoing, significant irregularities. And I have filed an affidavit with the criminal authorities in the matter. But there is a big difference between criminal negligence or criminal conduct and sheer stupidity. I'll give you an example. If I decide to buy Elarine's furnitures for 10 billion rand, it's a very, very bad business decision when it's probably worth 2 or 3. I then run a business model that buys a bed for 100 rand and I sell it to Terry for 90 rand at 36% interest plus 10% insurance. Right? So under Twin Peaks, we have the ability to scope all 3 entities, the furniture retailer, the insurance company, StanGen, and African Bank into the scope of conglomerate supervision. Under the Banks Act, we didn't. We only look at the bank, the FSB looks at the insurance company, and nobody looks at the furniture retailer. So you've got large profits in the insurance company, some profits in the bank, and massive losses in the furniture retailer. Right? But there's no evidence that there was fraud. If there is, it's not up to me to decide that. Right? We've conducted an inquiry. We've handed the findings of the inquiry to the criminal authorities. We filed a complaint in that regard. In our view, there isn't any evidence that there was fraud. There were some really bad decisions, poor corporate governance, weak systems, greed. There's a difference between that and a crime of fraud. Right? And I shouldn't be the one to judge that. It's the criminal justice system that must do that. So, Chair, we fully subscribe to your transformation objectives of the financial sector. We are doing absolutely everything in our power to advance that. We accept that the collapse of VBS is a failure. We genuinely hope that somebody would apply for a banking license, a mutual banking license preferably, and will provide a similar level of services to the community that was served. I hope they do it because they'll start on zero. If they want to take over VBS, they'll start on minus 372. At a profit of about 30 million rand a year, it would take them about 12 years to break even if they start on minus 372. It makes no logical sense to start on minus 372. Right? It makes sense to start on zero. So, Advocate Mutau, I've left a few to you.
Thanks, Chair and members of the committee. One of the things that one can appreciate is the fact that when it comes to legal matters, there's a reason why you have a number of volumes of law reports which contains judgments, and I have no doubt that when parties went into litigation, each of them was advised that they have good prospects of success, and only one party emerges victorious. It may be, the result might be accepted after the first court pronounces, it might not, and so forth and so forth. By that I mean, you're quite aware that in the public domain, for example, let me use the one person that has been mentioned here, and I quite understand why Mr. Ndlozi mentions Mr. Brian Shibambu. I don't need to deal with it here. It's understandable that why he selects that particular name, when in that list there are a number of other persons that are mentioned who received monies through companies, but they've been mentioned by name. But whether it's permissible or not, I'm not going to debate that. If Mr. Shibambu is going to bring that case will be answered in those proceedings, because what he has made clear is that he is going to be challenging, and one of the things which seems to be the central theme among those that are challenging, including the application that has already been issued, is the question of Audi. For the reasons that I mentioned earlier, can I just be permitted not to deal with that question, because the question has squarely raised its head.
My Lord, I intend to take 5 minutes.
Okay, thank you.
I made the submission that the state attorney cannot decide or cannot advise a department on the funding issue based on their assessment of whether or not the nature of the allegation is in the course and scope of employment, if you recall that submission. I didn't extend that to yourselves. The submission I make is that the court is not entitled, on the papers that are before it, to make the far-reaching findings that my learned friend from the EFF wishes the court to find, that will have regards to the charge sheet, and to then conclude that this charge sheet demonstrates that these charges were not in the course and scope of employment. This court is not obviously in a position to assess the evidence that is necessary for it to come to that conclusion. I would urge this court to leave it to the Durban court or the Pietermaritzburg courts to make that determination, and then we can all be happy concluding that these allegations, which we say have no basis, are in fact allegations that are in the course and scope of employment. We stand by what we say in our heads of arguments in respect of our interpretation of Section 3. Finally, we know that this application has been brought to affect Mr. Zuma's preparation for his criminal trial. We know that because EFF wrote a letter to the state attorney or to the presidency to say that they would like to know that this funding will not be provided for Zuma when he appears in the Durban courts. So this application is intended to affect his preparation for that particular trial, because now he has to expend resources defending what he has the current agreement that would go a great deal in helping him to defend himself in that particular trial. So the Honorable Court must just bear in mind the safety I referred to of being here, and really accept that its constitutional role is very critical to how they see litigants and how they decide on litigants. And I say this because we do make the allegation that the EFF and the DA largely make political arguments, not legal arguments. Arguments that his reckless litigation, there's no basis for that. Arguments that there's no accountability, he litigates with abandon. Those allegations are allegations that are good at a political rally, not in this court. And because we're in this court, we are safe, because we know that the court will look at the facts and pay attention to the facts. If you make the orders that they ask you to make, they are no doubt going to be celebrated in the political rallies of the DA and the EFF. And no doubt that in Parliament you will hear stories about how the DA has been championing the accountability ticket and ensuring that Mr. Zuma finally goes to court. Mr. Zuma wants to go to court, but he's here now defending a facility that would help him to focus on his case. So the court mustn't assist the DA in its political strategy and the EFF of building up a political profile by just throwing terms that are very critical for our democratic institutions, accountability, but with no basis whatsoever. It is, we submit, wrong. But finally, on the authorities that we submitted, you cannot even go to the review application. Let's just deal with whether or not the DA and the EFF have in fact persuaded you that there is some interest of a constitutional and legal nature that should turn things in their favor and have the review application heard. You are bound by the Supreme Court and Constitutional Court judgments on that issue, and would submit that it's very important that that procedure is followed, because it is a procedure that's been established as the basis of our review law. That where a party is delayed, the party must explain. It empowers the court to engage with the issues a bit more thoroughly when a proper substantive application is brought. Here it wasn't. And so and I end with how I began. This case should have started exactly there. The question this court should ask is whether or not there is a substantive application, the basis on which it should condone the undue delay in bringing these review proceedings. If it comes to the conclusion that there has been, on both the EFF and the DA, there are no applications on which the court to grant any extension or condonation, and therefore the court should not engage with the review. Would ask for costs, including costs of true counsel.
Before you sit down, Mr. Masuku, on the question that the preparations would be affected if we find in favor of the applicants, In one of the undertakings that were signed by Mr. Zuma, he said that he can pay the legal fees on demand. And there's nowhere where he states that he does not have the funds. Would you agree?
Yes,
So if we rule in favor of the applicants, Mr. Zuma can still fund his legal fees, is it not?
There are two submissions I want to make. Firstly, the demand is not coming from the state attorney. So there hasn't been any demand from the state attorney. He has not prepared for that demand as yet. When they do make the demand, in accordance with the undertaking, they will engage each other, and the terms of the payment will be determined by that engagement. What is happening is that two political parties are asking you to make that determination. Mr. Zuma has made it, or is put it on record that it's not going to affect his funding. Obviously, affect his preparation. I'm part of his legal team. I'm here arguing a different case than preparing for the permanent stay, which we say will succeed in the Pietermaritzburg court. But I'm here arguing this case, and my attorney is here arguing this case rather than focusing on that case. So we say that however you go, if you should find your way past the condemnation and you go into the review and you come to the conclusion that the state attorney can enforce this agreement, or because you don't have to make that finding actually, because that's what it is. The agreement is such that the state attorney can actually enforce the agreement at whatever time they decide to force the agreement. But obviously, if you make the determination that they had no legal authority to advise the departments to fund this litigation, then of course there are problems. But let's just be, and I mean not disrespect when I suggest that let's just be ordinary people. If he order that he pays on demand, that's 32 million according to the EFF, 16 million according to the DA, or as conveyed to them by the president. Just let's be ordinary. That means in the middle of preparing for his criminal trial, that's the amount he must pay, and also pay for the criminal trial itself at the time that the trial is running. So we're saying, I mean, people living in a normal environment would understand that such money is not there for the taking, and that's not to say that he has not made arrangements to pay back the money should he be asked to do so by the state attorney in accordance with the agreement. But what we're being asked here is not the state attorney coming to you and saying, please enforce this agreement. You are being asked by political parties to say that in the name of accountability and other legal reasons they have advanced, you must order that Zuma must pay 32 million or 16 million within 6 months or within whatever time that it suits them. So the repayment order that you would make would invariably affect, obviously, his defense, in the sense that now he must immediately, within these next 16 months, find 32 million somewhere, pay it, and then also find some money to defend himself. And we say, obviously, you would have assisted the political parties to divert Zuma's focus on finally getting a platform, a proper, safe platform to clear his name that has been tarnished over a long period of time. And I know they will have statements to say about that.
Our duty here is not to assist any political party, and as a court, we will have to decide on the facts that is based before us.
I'm heartened by that, my lord.
Thank you, Mr.
Those are our submissions.
Thank you. Mr. Rosenberg?
Thank you, Justices, this case is about decisions that were taken at the level of the presidency, in the presidency, to appoint a private legal team to represent Mr. Zuma in his criminal trial and in related litigation. And in that sense, it is a funding decision, and in that sense, in that connection, there has been reference to non-compliance with provisions, for example, of the PFMA. As to the legal or statutory basis for those decisions, the case that has been put up on behalf of the presidency in the DA's application is quite clear. It's based foursquare on section 3.1. Alternatively, for the purposes of the argument, one can accept that 3.3 at various stages was also taken into consideration. But for present purposes, it doesn't matter. That is the basis which has been put up for the funding decision. And the submission that we've made, which with respect doesn't appear to have really been addressed adequately, if at all, is the submission that Section 3 is not a funding provision. Section 3 of the State Attorneys Act is a function provision. As the heading to that section makes clear, it deals with the circumstances under which the State Attorney is to carry out its statutory function there described. And we say, and we submitted in our argument in chief, that on the basis of Liebenberg's case, in 237 of the authorities bundle, once the decision has been predicated foursquare on specific statutory provisions, in this case section 3.1 or section 3.3, then the decision maker is bound by those provisions which he or she expressly declared as being the authority for the decisions in question. And we say that on that relatively narrow approach, that section 3 is not a provision which provides authority for funding of private attorneys for a government functionary's criminal defense. The decisions may fail, must fall. We did submit that in any event, the requirements of section 3.3, the objective requirements of section 3.3, didn't find application, even if we were not dealing with, in fact, the funding of a private attorney or private legal assistance. We submitted, for a variety of reasons, that section 3.1 didn't find application because the government was not concerned party. We submitted for various reasons that section 3.3 didn't find application. Very limited argument was put up in relation to compliance with the objective requirements of section 3.1 or the objective requirements of section 3.3. As we understand it, the submission that appears to have been made was limited to a contention with reference to an analogy of, or an example of a judicial officer being charged with a criminal offence, and the reference or the submission appeared to be that even if it was a drunk driving offence as suggested by the bench, or even if it is an assault over the weekend at the golf club, whatever the case may be, the suggestion appeared to be that the requirements of section 3.3 would be met, and the underlying assumption is that if you're a judge or if you're a cabinet minister, government interests or the public interest, particularly government interest, is automatically implicated when you are charged with any offence, no matter how unrelated that may be to the functions of the judge or the functions of the cabinet minister. And with respect, that is not what our law provides for. We know that the proper approach is to have regard as the most apposite tool for determining whether on the facts a government interest or a public interest requires state funding for the functionary concerned, that there should be a sufficient link between the government, business, and the interests or position of the functionary concerned, and that has generally involved an inquiry relating to the course and scope. And we've referred to Kay's case. And we made the submission, which doesn't appear to have been challenged, that on the basis of the authorities that we referred to, as a general proposition, when a police official is charged with corruption, for example, in general, unlike the case of the police officer effecting an arrest, corruption charges tend to be regarded, or acts of corruption tend to be regarded as not being performed in the course and scope of employment. And we referred to the authorities in question. And to the extent that the argument in relation to that seems to be you don't follow that approach, and the mere fact that one is dealing with a high-ranking official or functionary satisfies the government interest test or the public interest test is in our submission clearly incorrect and an unsustainable submission. The result of that is we submit that no sustainable basis in law, no authority has been put up that would justify the decision. There might be authority elsewhere, one doesn't know. It hasn't been raised in this case. Section 3.1 and Section 3.3 has been raised in conjunction with Treasury Regulation 12.2. Treasury Regulation 12.2, on its plain meaning, has absolutely nothing to do with what we are encountering in this matter. With regard to the question of delay, the first submission is that counsel for Mr. Zuma doesn't address what we submit is the cardinal feature of the narrative in this matter which goes to delay. We submitted that on the 12th of September 2008, Advocate Segodi advises of an instruction to be given to the State Attorney to appoint Mr. Hulley and his team. So that's the September 2008 decision, and that funding decision, and that's essentially the funding decision, which in the first instance is the subject of the challenge, because it's the funding decision which apparently forms the basis of the defense campaign that is going to be launched on behalf of Mr. Zuma going forward in relation to his re-indictment. But shortly after the funding decision of late September 2008, the prosecution was discontinued. April 2009, the prosecution was discontinued. And from that point onwards, effectively, the question of funding for Mr. Zuma's prosecution became, for all effective purposes, moot and no longer an issue of particular ongoing import and consideration. Now, of course, at that time, the DA and the other applicant, the EFF, had no idea of the decisions, what decisions had been taken, when, and for what purpose. Other than at about the same time, in fact, shortly before the funding decision of 2008 was taken, there was the very unhelpful exchange, both in regard to a rather broadly framed parliamentary question and the response to that, which went to the question as to what provision is being made for the recovery of any costs incurred. In Mr. Yes, in 2008, at the time that the parliamentary request or question was submitted, it may be accepted from the answer that the state had, and it may be inferred from that answer, that the state had paid certain costs in relation to Mr. Zuma's defense. That may be accepted. It didn't know the basis, when a decision had been made, by whom, and the detail of that decision. And the submission is that at that time, the question then is, post-September 2008, to what extent would it be reasonable, or is there an obligation to try and find out details of whatever decision had been made to fund Mr. Zuma's litigation, a defense? The reason why we submit that it wasn't reasonably to be expected of anybody to pursue details of, or to try and obtain details of the decision, who had made it, when it had been made, is because the criminal charge was withdrawn at that stage. That, we submit, is a very significant feature. The criminal charges, or the re-indictment, takes place 9 years later, in March of this year. And the question which then has to be decided is, was there a lapse of a reasonable time between the decision which is relied upon as the funding decision going forward? We've made the point that as to the decision in question, it has emerged in the papers and in the explanatory affidavit filed on behalf of the presidency that ultimately it was the September 2008 funding decision which was regarded as being a decision which continued to operate. And in those circumstances, the question would then arise as to, was the lapse of time reasonable or unreasonable in the circumstances? And if I could just flag one issue here, because I'm going to come back to it, or perhaps I could profitably deal with it now. The question of whether there has been an unreasonable lapse of time and whether condemnation is required in the interests of justice only requires to be addressed if it is found that on its terms, the funding decision of September 2008 continues to be of application to the funding of Mr. Zuma's defense from March 2018 going forward. The court has our submissions that the funding that was undertaken and assented to in September 2008 was for a different team, in different circumstances, for different tariffs. It was never intended to be funding for a re-indicted criminal proceeding some 9 years later. No submissions were addressed on that contention. Yes.
in that 9 years?
Now, I will go back to deal with, in a moment, the question of whether that lapse of time was reasonable or unreasonable, because that's the inquiry that has to be made. And in that regard, it's not just a question of 9 years, it's a question of the lapse of time in the particular circumstances, having regard to the facts as a whole. But the point that I'm making, and I have made, and I'm going to move on from that, is that if the court should find that the decision to fund, which is relied upon by the presidency in September 2008, doesn't find application to the question of further funding in 2018, then the question of reviewing that decision doesn't in the first instance apply. Insofar as the narrower question then is Mr. Zuma entitled to funding going forward? And the presidency has said in that regard, it adopts the approach that the September 2008 agreement is extant and fit for purpose. We've made the submission in that regard that there is no ongoing extant agreement in relation to funding going forward. But that doesn't deal, that's obviously just a confined aspect of the matter, but it's an issue which nonetheless requires to be addressed. And it's an issue which would require an approach.
But the relief you see also concerns,
of course,
the period prior to.
Of course. I accept that. That's why in the first instance, that is a submission that is confined. We accept that, but the relief that's sought goes beyond that, and that's why I return now to the question of the lapse of time. And in relation to the issue of the lapse of time, the Promotion of Administrative Justice Act, in section 7(1)(b), provides for the institution of proceedings within 180 days of the time from which the applicant or the person concerned becomes aware of the decision and the reasons for it, or might reasonably be expected to have become aware of the action and the decision. So it's a question of from what time might a person reasonably be expected to have become aware of the decision. And in those circumstances, that inquiry requires an evaluation of all the facts and circumstances. If one could perhaps, for convenience, refer to Kamalo's case, which is at page 230 of the bundle of authorities, and that of course is dealing with the question of the common law test, the two-stage test for determining, one, whether the period is reasonable or unreasonable. It's an objective inquiry. And thereafter, for determining whether, or that's a factual inquiry, and thereafter exercising a value judgment in the circumstances of the particular case. And that's at paragraph 49, where the court endorsed the decision of the majority in the Supreme Court of Appeal that an assessment of the question of undue delay, it's page 235 of the bundle, involves examining whether the delay is reasonable or undue. A factual inquiry upon which a value judgment is made in the light of all reasonable circumstances. And then, if on the basis of that factual requirement, it's concluded that the delay was unreasonable, then the court, in the exercise of its discretion, is entitled to overlook the delay and nonetheless entertain the application. So the question whether or not the delay in challenging the operative decision, because that's the first question, the operative decision was taken to fund in September 2008, whether that delay was reasonable or unreasonable in the circumstances. And we've submitted that this court should find that in the particular prevailing circumstances, that delay was not unreasonable, because in the circumstances of this matter, we know that each time the prosecution was withdrawn, for example, in September 2006, a subsequent decision then has to be made for funding going forward if and when the matter proceeds. In this case, after the withdrawal of the decision to the reversal of the decision to prosecute, in those circumstances, from early 2009, there was no need to find out or to investigate the decision and the reasons for the decision. And the question then is, when should the applicant reasonably have become aware of the decision and the reasons for it? And our submission is, in those circumstances, it would have been unreasonable to expect that the DA in this matter would have sought to challenge and hence find out the basis of any decision of which it was unaware at that stage to fund the criminal defense of a case which was not proceeding. And it became a matter of considerable public import 9 years later, because 9 years later, there was now not only the knowledge of how the matter had played itself out from 2005 to date, but also the fact that the narrative, the playbook was about to start afresh. From March 2018, the clock had been rewound, and there's every prospect, given what Mr. Zuma's defense team indicated his intention was when the Supreme Court of Appeal heard the DA review, that much of the strategy, the defense strategy, which had been employed over the preceding years, was going to be employed again. And we've heard as much from counsel for Mr. Zuma as to what the first planned step in that campaign is. And that is why it then became a matter, in the light of the re-indictment, of pressing public concern. So our submission in that regard is that the delay was not unreasonable. If the court is of the view that in the circumstances the delay was unreasonable, it's then a question of condemnation of that and whether in fact there are public interest requirements or considerations which have a bearing on that. And I would submit that there are compelling reasons that this court should exercise its discretion. We deal with those in paragraphs 97 of our heads. And with respect, it doesn't appear to us that those particular public interest considerations, which we say are compelling, have been addressed in argument on behalf of Zuma. We submitted that the matter was one where the interests of justice overwhelmingly favor granting the extension. Perhaps I could ask you to turn to page 45 of our heads. There's been so much paper in this matter that one is inclined to resist going to the sections in question. But if you were to have regard to paragraphs 97 of our heads at page 45, we make the point that the interests of justice overwhelmingly favor the granting of the extension. The matter is of obvious public importance, not only because of the sums of money involved, but in fact more compellingly because of the issues that it raises. The issue of state functionaries seeking state legal assistance in the context of corruption charges is of obvious public interest, particularly at the time that we live in, whether it's in the wake of the state capture report or investigation. The issue of the circumstances under which government functionaries facing corruption charges are entitled to legal assistance at state expense, and not only the state attorney, but private legal assistance, cries out for consideration by this court. So that is the first, and what we submit is a compelling public interest factor. Secondly, we've submitted that the state is continuing to pay Mr. Zuma's interest and that it will continue to do so. We've made the point that one can look at in the rear view mirror and see clearly what has occurred in this matter, and we would invite the court, if necessary, to have regard to the comments, and I'm not going to read them to the court, that the Supreme Court of Appeal made in relation in the judgment where it ultimately set aside the decision to withdraw the charges by the acting NDPP, to the account by the Supreme Court of Appeal of the manner in which and the duration over which the criminal charges and related litigation had been handled. And we say it is in the public interest that questions of unlimited state funding as a device to enable luxurious and never-ending litigation, the recurring end of the never-ending, I think NAVSA AA referred to it, is an issue that calls for determination by this court.
I would like to remind you that in our discussion, you said the reply should take more than 30 minutes.
I'm going to...
You're left with about 3-4 minutes.
As the court pleases.
Yes.
And in paragraph 97.4 and onwards, we deal further with related aspects of the same point. So, in those circumstances, we submit that on the delay issue, the period of time was not unreasonable, and the court should find that. If it was or is to be construed as unreasonable, and it is to be contended that in fact, notwithstanding what I've indicated, parties should have instituted further investigations to try and find out what they didn't know. It's common cause that the parties didn't know of the what particular decision had been made and when and what the ambit of it was. We submit that public interest considerations require intervention. If I could just conclude with dealing with the terms of the proposed order that we submit should be made. If I may hand up a copy of a draft that we've prepared for the court's consideration. Has Tabani got a copy of it? The amended notice of motion is at record volume 1, page 64, and the relief or remedy that is sought is essentially for a setting aside, for the reasons we've given, of all of the decisions to provide legal assistance or to fund legal assistance. And related to that, we've sought and continued to seek the necessary declarator that we've provided for in paragraphs 1 and 2 of our original notice of motion. If I could, before directing your attention to the provisions of the draft order, deal with one aspect, and that is the question of repayment. The approach that has been adopted in the DA application is that essentially Mr. Zuma is the beneficiary of the payments that have been made. He has received the benefit of the legal assistance. It's legal assistance which presumably he would have sought and paid for anyway. This is directed not so much at getting his legal team to disgorge or repay what they've received. It is appropriate remedial relief addressed at the beneficiary, and that is Mr. Zuma. And for that reason, we submit any repayment order is on the basis that Mr. Zuma, as the beneficiary, must be the party who repays. We've made provision in the draft order in paragraph 1 for the declarator in question, and this is a draft order which, as I understand it, has been prepared to serve as a draft order in both applications. It may be that in the course of debate with counsel for the EFF certain deviations might emerge, but speaking from the perspective of the DA, paragraphs 1, 2 and 3 go to the declarator, and the setting aside which we've sought in the amended notice of motion. As far as the repayment is concerned, we've refined that provision, whereas in paragraph 4 of the original notice of motion at page 65, we have just provided for an order that Mr. Zuma be directed to repay to the National Treasury any and all such amounts that have been paid. In the light of the difficulties which have been thrown up as to the amounts in question, and in order to facilitate clarification of those amounts, we've provided for an order where the state attorney, who's a party to these proceedings, and who was the conduit who made the payments on behalf of Mr. Zuma, and presumably recorded those payments and is in a position to collect detail of those payments, we've made provision in the order for the state attorney to provide an accounting of those payments as a necessary first step to give meaning and content to a repayment order. And then in 4.2, we've provided for the state attorney to take necessary steps, including the institution of legal proceedings to recover the amounts paid by the state to Mr. Zuma, for Mr. Zuma's benefit. Those are the submissions.
What, in paragraph 6, why cost against the first to fourth respondents? They are not even opposing this application.
Your Lordship is quite correct. As far as the DA is concerned, that is an issue which has been introduced into the order and reflects essentially the EFF's.
No, the EFF is 29. EFF is number 7.
Yes.
And they only seek costs, or it only seeks costs.
Your Lordship is quite correct that in the DA application, the costs that initially were sought in the notice of motion.
I'm talking about the draft order that you handed down.
Yes.
In paragraph 6 there are
yes.
Cost in the DA application is also sought against the first to fourth respondents.
Yes, it should be the first to the second respondents. We will make provision.
No, but they are not opposing the application.
Well, effectively the presidency, costs were sought against the presidency in the notice of motion origin, not necessarily confined to circumstances whether the presidency opposed or not. Costs that were originally sought were against the first respondent and against the fourth respondent.
So in other words, you persist with that.
We persist with the order for costs against the first respondent and the fourth respondent. And I will make the necessary adjustment to address that particular error in paragraph 6. First and fourth respondents. As the court pleases.
And if the court will grant me the indulgence to address from here. You have, there is a microphone. Thank you. Let me start with delay. I want to make 2 submissions on delay. The first is in reference to the Kumalo judgment of the Constitutional Court. My understanding, my learned friend will correct me if I'm wrong, was that he says that we were under a duty to apply for condonation, even though we brought a legality challenge. This point is answered authoritatively in paragraph 44 of Kumalo. And that concept of power to regulate their own. Mr. Rosenberg, around the public interest. What takes this case outside the norm is the concept of a continuous wrong. It is true that the first decision to find Mr. Zuma was made in 2006. It is true that the second decision was made in 2008. But the wrong that began in 2008 is continuous. Every time counsel is briefed, every time an attorney is engaged, an invoice is submitted, that wrong is continuous. This is precisely the finding in the Barnett judgment in paragraph 20 and 21. there's just been no engagement with that principle.
That's the judgment that you referred us to when you addressed us in the chief.
Indeed. And briefly, the facts were
By Brandt in the ECI.
by Justice Brandt, yes. Land was occupied, the government comes to court 4 years after the occupation. The occupiers say, sorry, your claim is prescribed. The SCA says, as long as that wrong that began 4 years ago is continuous, you are not out of time. And this is why this case is outside the norm of a review that's granted, frozen in time. And again, there has been no engagement with that principle. So on those two grounds, and we know, if I may add a third ground, but I made the point in my original submission, we know that Mr. Ramaphosa says he will continue funding to the future. We know that Mr. Zuma, in his answering affidavit, expects funding to the future. So not only is there a continuous wrong, even for the future, they will continue funding. The only thing that will stop them from continuing this funding is a judgment by this court. So the delay point is a non-point. And unlike the DA, in paragraph 2 of the notice of motion of the EFF, we specifically challenge each decision to pay. Again, you had no submissions at all about why each decision to pay is itself time-barred. And the most recent events took place in March 2018. They even tell us, subsequent to March 2018, we are still going to challenge the application. We are still going to challenge the decision by Mr. Sean Abrahams to reinstate the charges against Mr. Zuma. So we would submit with respect, the delay point can be disposed on the simple principle of a continuous wrong. The second argument I want to make in reply is around the PFMA. Your Lordships will recall the complaint by my learned friend that the PFMA has no application, and in fact it would be impractical to apply it. How the PFMA came into the equation was in the answering affidavit by the state attorney. And that answering affidavit is at volume 2 of the EFF bundle. When they explain why they took the decision, they invoke section 3.1 and 3.2, but also at page 89 of volume 2, paragraph 7.1. This is what they say. The aforesaid provisions are further galvanized by the Public Finance Management Act, and then they quote section 3 of that act. And then later on, at page 91, they summarize in paragraph 9, the aforementioned provisions of the State Attorney Act read with the PFMA and the Treasury regulations entitle members of cabinet or state employees who are liable for acts committed in the course and scope of their employment to legal assistance at the instance of the state. So it is the decision maker, the state attorney, who comes to court and says that I have authority, A, from the State Attorney's Act and from the PFMA. We say in response, if the source of your authority is the PFMA, quite independently from the State Attorney's Act, if your source of authority is the PFMA, it also prescribes a procedure. And the PFMA complaint is twofold. One is, what procedure did you follow when you engaged the services of Mr. Hali? We know on the facts that they followed no procedure whatsoever. The second aspect of the PFMA is financial controls that are prescribed in section 38. In relation to that, there is plenty of evidence on this record that initially, certainly in 2007, it was intended that because of the expenditure of public funds, there would be constraints on the funding and there would be constraints on how the money is spent. So we argue that A, in relation to the PFMA, which the State Attorney claims to have relied upon, they never followed any procedure. Secondly, we say they failed to exercise financial controls. And the failure to exercise financial controls can be illustrated. One, they appointed the private attorney, and we know that under the State Attorney Act, they are not entitled to appoint a private attorney. The State Attorney himself must perform the functions. Number two, when they engaged the private attorney, they did so without any advice being obtained. The learned judge presiding put the question to Mr. Masuku, he couldn't answer the question because on the facts it's incontrovertible. Number three, Mr. Zuma was funded for the watching brief in the Sheikh trial, way before all this began. Number 4, if one looks at the DA record in relation to the Leveson judgment, Mr. Zuma was specifically told that we are funding you on the basis that if you fail, you will pay. That was in 2007. We are sitting in 2018. The state attorney made no attempts to exercise the financial controls imposed by the PFMA. Number 6, we know that there was never any decision that Mr. Zuma would be funded for an adverse cost order. But we know in this case that the adverse cost orders against him were funded by the state. It's completely unauthorized expenditure. And it's completely wasteful expenditure. Both of those concepts, an unauthorized expenditure, an irregular expenditure, and a wasteful expenditure, are Section 38 concepts of the PFMA. Number 7, we also know that in relation to the Nicholson judgment, which was the interlocutory application, it was also granted in 2008 on the basis that if Mr. Zuma fails, he will repay. 10 years later, there has been no attempt by the state attorney to recover the money. So those 8 indicators simply show that there has been a gross mismanagement of the funds in this case. All of the checks and balances in the PFMA in relation to financial controls were not complied with. So we say in sum, 1, no procedure was followed to appoint, and 2, there was no prudent financial management as prescribed. So their reliance on the PFMA actually doesn't help. What we know is that they violated the PFMA. And there are material consequences to this failure. If you take the 2007 decision where they said, we will pay you, but if you fail, you must repay us. If they were to claim the money tomorrow, as we are proposing in the draft order, that claim most likely has prescribed. The same way as the claim in relation to the Nicholson judgment. If they instituted tomorrow, that claim most likely has prescribed, which means the public has been left out of pocket by the pure mismanagement and negligence of the state attorney. The 4th argument relates to Section 8.1. The Lordship presiding, I think, put the question. It's clear that Section 8.1 of the State Attorneys Act is not a section that authorizes the appointment of a private attorney. It is a section that authorizes the appointment of a correspondent. Number 5, Section 3.3 has been argued substantially by the DA. We want to add only 3 aspects to it. Section 3.3 does 2 things. The first is that it sets out the authority test. In other words, who must provide the legal services? On the authority test, the services must be provided by the state attorney. The second element of Section 3.3 is to set out the substantive test. Under what circumstances will those services be rendered? This particular request by Mr. Zuma fails on both aspects of Section 3.3. It is not done by the state attorney, it is outsourced to Mr. Halley. But secondly, on the substantive question of cost and scope, it completely fails. It was interesting to listen to my learned friend make his submissions around the cost and scope concept, because even he could not justify the cost and scope argument by reference to the indictment, because the indictment clearly takes Mr. Zuma outside of cost and scope. In fact, it takes him in direct collision with cost and scope. And hence, the best argument that could be mounted is that no, the court shouldn't decide the cost and scope. It should wait until the criminal trial is finalized. But of course, the argument cannot work. The criminal trial is not deciding cost and scope, it's deciding guilt or otherwise. The funding decision has been made now, and it was made on the basis of cost and scope. There is now a review based on the cost and scope. If it cannot be sustained on the basis of cost and scope, it should simply be set aside. So it's illegal, not only for the PFMA reasons, it's illegal also because it fails the test. Firstly, the test of authority under Section 3.3, also the substantive test of cost and scope. And finally, this case really is no different from the Nkandla judgment. What we are dealing with here is a president who has been enriched at the expense of the nation by the public. This is the same scenario that is governed by Section 96 of the Constitution. The Constitutional Court in the Nkandla judgment, paragraphs 8 and 9, that I would recommend the court to have regard to, explained the entire concept of a conflict of interest. And this is what is said there. In paragraph 8, the public protector's finding on the violation of Section 96 was based on the self-evident reality that the features identified as unrelated to the security of the president, checked against the list of what the South African Police Service security experts had themselves determined to be secure, were installed because the people involved knew they were dealing with the president. When some government functionaries find themselves in that position, the inclination to want to please higher authority by doing more than is reasonably required or legally permissible, or to accede to a gentle nudge by overzealous and ambitious senior officials to do a little wrong here and there may be irresistible. A person in the position of the president should be alive to this reality and must guard against its eventuation. Failure to do this may constitute an infringement of this provision. There is thus, paragraph 9, a direct connection between the position of the president and the reasonable foreseeable ease with which the specified non-security features asked for or not were installed at the private residence. This naturally extends to the undue enrichment. The president must have known when these payments were made that he was benefiting himself in his personal capacity and not in his official capacity. Nevertheless, he allowed the conflict to fester. And that is why this court, whether it is on condonation or on the merits, has to grant the order that is effective enough to make sure that he repays the money. I have no further submissions.
Is that the draft order that was handed down? Is that the proposal of both the DA?
Reluctantly, yes. If it were according to the EFF, he will pay back the money tomorrow. Yes. But we accept that it must be on the basis of a civil summons.
I think we should not repeat the mistake that was made in the directive. The case number on paragraph 7 is 29984.
Well, my case number is 29984/18.
Yes, but in the draft order, it's 29484. The mistake that was made in the directive.
I have Mr. Rosenberg Jr. to blame.
Okay. 29984.
All right. I think, my lord, I am the one making the mistake. It looks like it's 29484/18.
The right case number is 29984/18.
No, I'm being confused by the DA again. the current case number is 29984/18.
Yes.
That is my case number.
Okay. Mr. Mabena, do you want to make a submission?
Yes, my lord. I know for sure that the first and the fourth students have not filed answering affidavits, and they indicated that they abide by the issue of this court as early as needed after the notice of motion was set upon them. I'm talking about the question of cost. So, my lord, I know that under the circumstances, I'm not supposed to be attending the proceedings to make submissions on the basis that no papers were filed before this court. But the question of cost, my lord, we submit that if I'm permitted to carry on with my submission, my lord, the question of cost, we submit that the first and the fourth respondent should not be subjected to that because they've indicated their abidance right from the inception of the hearing. So I submit that they should not be marketed with costs for whatever reason. Unless your lordship would like to hear me on any other aspect of that. I know I'm not supposed to be here, but I'm here.
Okay, we heard you.
Oh, thank you.
Mr. Anwar, I told you, I don't want any confusion later. In your notice of motion, okay, in your papers,
Yes, my lord.
the first respondent is the state attorney. And on the draft, you you seek that cost be paid by the first respondent, and we should not make any cost against the second respondent.
No. What we, in our notice of motion, the state attorney is first respondent,
yes,
and Mr. Zuma is second respondent.
Yes.
And
in the draft,
the
draft order that has been presented to us.
Paragraph 7 of the draft order.
And okay, I need a copy.
You're gonna bring the DA again.
No, my lord. The intention is that they must be paid by Mr. Zuma, the second respondent.
So that's
and that's consistent with paragraph 4 of our notice of motion.
Okay.
I wonder if the court has corrected case number. It's not 294, it's 299.
Yes, that has been corrected.
Justices, we also want to make sure that there's no confusion, and I just want to clarify to the extent that it hasn't been clarified, and we will amend the paragraph where our costs are sought for the DA. Costs have since the outset and continue to be sought against the first respondent, the President, and the fifth respondent, Mr. Zuma. Those are the costs that the DA seeks, and we will amend the paragraph that caused the confusion, paragraph 6.
Mr. Rosenberg, let me understand you. First and fifth only, not fourth.
Yes, first and fifth only. From the outset it has been, and I'm sorry for the confusion in the draft order, it has always been the case that the cost should be paid by the President and Mr. Zuma.
Thank you. Would like, on behalf of my colleagues, would like to thank all counsel for detailed and very informative arguments that were made, which we think they will help us as we prepare the judgment. We're going to postpone the matter sine die for the judgment, and we'll try by all means to let this judgment be delivered before the end of this term. Court adjourns.
Thank you.